Um, I've been asked to talk a little bit about the South African Constitutional Court's contribution to transitional justice. And I must say that the previous speakers have spoken, I think, with a lot of intimate knowledge of the situation in South Africa today. I'm going to speak a little bit as a sort of outsider. I've lived and worked outside of South Africa since 1990. And so, one of the things I'm very aware of is the practical realities of how things actually play out at home are quite different from the way one might see them from the outside. So my comments are really about how others outside may look at the South African experience and some of the lessons people are taking from the South African experience, and particularly the Constitutional Court decision in the case of Azabu. And I'll leave it to my colleagues to put nuances whenever sort of the reality of day-to-day life contradicts the sort of veneer that we might have overall. I'm going to try and, in today's talk, blend together a little bit of the history of the Center for Civil and Human Rights, the TRC, and my own personal history. One, because I think you all will then feel that there is, in fact, a very tangible connection between Nuruddin, the Center for Civil and Human Rights, and Transitional Justice and the Truth Commission in South Africa. And that there's a beautiful sort of line that one can trace through Ted Hesburgh's involvement in the civil rights struggle in South Africa to the work of the Holy Cross Order, Bill Lewis, and Chile, and then South Africa, and then international justice more generally. So forgive me, this will be a little less academic and a little bit of a weaving of the histories of Nuruddin, South Africa, and international justice. One other comment before I start. When I was in Taiwan, several of the people I met with, they've just interestingly had a transition, and the Greens, not the Greens as in the environmental Greens, but they have a political distinction between the Blues and the Greens, and the Greens have won and are fixing to come into power in Taiwan. And they're thinking of having a truth commission of some kind in Taiwan. And everywhere I went, I met with several high-ranking government officials and sort of the Minister of Justice in waiting. They talked about the South African experience, and they talked about having recently had Albie Sachs there as a visitor. And that immediately caused me to cringe a little bit, because I'm not sure that the South African experience is necessarily uniformly a good example for everyone to draw on. There are good things about the truth and reconciliation process, and there are some bad things, and I think that it could easily become a license for governments to not do the right thing in terms of dealing with their past. And if I can say so, it's difficult to criticize somebody like Albie Sachs, who is considered to be a hero by many in the struggle against apartheid. He was blown up in a car bomb and lost an arm in the process. But I think Albie Sachs sometimes should be a little bit more careful in speaking about the truth and reconciliation process, and particularly the amnesty part of it. I think that he represents a very generous victim who himself has embraced his perpetrator and forgiven his perpetrator, but he sort of creates an expectation that all victims should do what he has done. And I'm not sure that that's entirely fair. And I think the truth and reconciliation process in part played out in a way that sort of created the expectation of what, sort of the role of good victims versus the role of victims who weren't as forgiving. And I'm not sure that that's entirely fair. But so I say this my comments and my criticism today is partly because I think when talking about the South African experience, we should be a little bit careful about preaching to others about the example and sort of being too smug about the truth and reconciliation aspects. I think a lot of the credit that the process gets for reconciliation is really less about what the process did and more about the nature of the struggle and the incredible work and leadership of people like Nelson Mandela. I think they created the conditions for reconciliation. And if you were an outsider just looking at the TRC model and thinking you could borrow that and apply it and get the same result, I'm not sure that would be correct. So a couple other preliminary comments before I get started, and that is, first, in talking about transitional justice, I'm not really sure that that there is such a thing as transitional justice. I think there's international justice, and I think there's international justice in the context of a transition. But I'm not really sure that international justice in the context of a transition is anything other than international justice, or should be. I think we should be careful about the idea that there's somehow a special kind of justice that applies in transitions. Many seem to think that there is, and I'm not sure that that's true. I think we need to be careful about creating a double standard of justice. I think justice should always be contextualized and sensitive to the local realities of the environment. And then more generally, I think the international justice paradigm is really at a crossroads today. Not because the goals are not worthy goals, but because I think that, in particular, the sort of top-down approach to international justice is proving to have a lot of challenges. And I think, in fact, if you listen to the previous presentation, some of the tremendous work that is being done locally to struggle for justice and to sort of from a bottom-up approach try to facilitate social change, I think is more the likely direction that we will be taking in the future if we are to be successful. But that's a larger debate and one that I think is beyond the scope here. So let me then start with talking about the Constitutional Court's decision in a case called Azabu, the Azanian People's Organization. It's a decision that came before the Constitutional Court early in the court's history and was rendered in 1996. And it was a decision in which the Azanian People's Organization challenged the Truth and Reconciliation Commission Act. And in one particular provision of the Truth and Reconciliation Commission Act, Section 22, which provided, Section 20, subsection 7, which provided for amnesty. And this is probably the most controversial part of the Truth and Reconciliation Act. And the plaintiff sought to challenge the constitutional validity of the Truth and Reconciliation Commission Act's granting of amnesty. This was always going to be a very hard case to make. Why? Because the Constitution itself, in the epilogue, for those of you unfamiliar with epilogues, it's sort of the opposite of a preamble. It's sort of a postamble. It's a clause that came into the Constitution right at the end. And there's some rumors about how that happened, because it didn't seem to emerge entirely from the democratic discussions and negotiations. It seemed to mysteriously appear right at the end of the negotiations and get adopted along with the rest of the Constitution. But the epilogue very explicitly says that there will be an amnesty in South Africa. And so, a constitutional court created under the Constitution to enforce the Constitution with an epilogue that says there will be an amnesty does not have a whole lot of room to say, no, this amnesty is unconstitutional. So it was always going to be a hard case. Why did South Africa adopt a Truth and Reconciliation Commission? And it's worth taking a step back and looking at the context at the time. South Africa apparently got the idea from others. And here's where I'm going to digress a little bit and weave in some history. There were a series of brutal military dictatorships in Latin America, often referred to as dirty wars, during which a particular tactic was used called disappearance. And disappearance, for those of you not familiar with the term of art, is a reference to situations in which the state is seen or suspected of having been involved in the apprehension of someone and then the subsequent disappearance of that person, with complete denial by the state of any involvement and a failure by the state to do anything to establish the whereabouts of that person. And you have to keep in mind that this is not just the same as, political repression and assassination. This is a particularly heinous crime, because for years afterwards, the families, the relatives of those who are disappeared yearn for some understanding, some knowledge of what happened to their loved ones. And if you go to a place like Buenos Aires, Argentina, and you walk down the street, you can see how victims will for decades walk down the street and see a face in the crowd and think, that's them, and not know. And it's that reality, that haunting reality of this legacy of people who vanished. In Argentina, there are claims as many as 30,000, at least 10,000 people disappeared, but possibly as many as 30,000 people disappeared. That created a context in which subsequent governments had to do something to investigate the past and to come up with some accounting for what happened. In Argentina, a lot of these people who were disappeared ended up in no-name graves. And there's a photograph on the cover of a New York Times story which shows exhumations of these graves where bulldozers were used to unearth the graves. And then you just have this pile of bones. This was clearly not a forensic exhumation. In fact, someone called Clyde Snow, a forensic anthropologist, saw this on the New York Times and then immediately got on a plane and went to Buenos Aires to create a forensic anthropology team to help with exhumations there. That experience in Argentina led to a report called Nunca Más, which was a bestseller in Argentina about the dirty war and about the disappearances. And then when Pinochet gave up power in Chile, there was an immediate expectation that Chile ought also to have a truth commission. And here is a connection then directly to the Center for Civil and Human Rights. Notre Dame has long had a strong relationship with Chile because there's a Holy Cross order presence in Chile. And many priests here have worked in Chile, including at a school, St. George's College in Chile. And during the Pinochet years, one of the opponents of Augusto Pinochet's regime turned out to be the Catholic Church, because the Catholic Church created an institution called the Vicaría de Solidaridad that was based at the Catholic Church, that provided legal assistance to victims of repression. And for the entire Pinochet dictatorship period, there were lawyers at the center who interviewed victims or relatives of the disappeared and took sworn statements about the disappearances. And this created a huge archive of information about Pinochet's repressive acts. And Catholic priests here from Notre Dame went back and forth to Chile and smuggled copies of the files from the Vicaria out of the country on microfilm to make sure that there was a complete archive of the files available here at Notre Dame in case Pinochet seized the Vicaria, which he never did, but there was always the fear that he would. So when the Truth Commission was created, the Truth Commission had the benefit of this tremendous archive of files that it could go to, sworn statements taken with meticulous care by lawyers who interviewed relatives at the time or approximate time of the actual disappearances. And so this became a rich resource for the Truth Commission report. I was very fortunate that Bill Lewis had been in Chile during the Pinochet years. And in fact, Bill had stood up in his own way against Pinochet. There's a great story that Pinochet was fixing to seize St. George's College because there was the likelihood of student protests. And so Bill got on a plane and flew to Delaware and incorporated St. George's College as an American corporation. And then went back to Chile and announced that if Pinochet was to seize St. George's College, he would be seizing an American corporation. And that then changed the stakes considerably. And St. George's College was never seized. So Bill had just returned from Chile and was as director of the center. And he and I talked and talked about South Africa. And he said, you should go and see what has happened in Chile. And so after I did my LLM here, I went to Chile and I met with Jose Zalaquet and members of the Truth Commission. And I was so impressed by the experience of a society dealing with its past that I came back to Notre Dame, and Bill and I talked and said, there ought to be a translation of this Chilean Truth Commission report, which was 3 volumes. And so Notre Dame undertook to translate the Chilean report and to publish it in English. And that report is called the report, it was informally named the Rettig Commission Report, but the name is the Report of the Chilean National Commission on Truth and Reconciliation. And it was around 1994 that we had completed and published this report, and we made sure that copies were sent to South Africa, including to the Minister of Justice. It was not long thereafter that South Africa announced that it too would have a Truth and Reconciliation Commission. And it then invited several of the Chileans who'd been involved in the Chilean process to South Africa to give advice on the South African Truth Commission. But the South African process did something which the Chilean Truth Commission did not do. And that is, the South African Truth Commission added a provision providing that individuals could come to the Truth Commission and confess their crimes and then receive amnesty. This is something that no other Truth Commission had previously done. And this is the issue that became the subject of the challenge before the Constitutional Court in the Azabu case. Before I talk about this case, let me just say that the structure of the Truth Commission was that there were essentially 3 parts to the Truth Commission. There was a part that was mandated to investigate the past and to hold hearings. And this was the part presided over by Archbishop Desmond Tutu. And one of the sort of unique and I think slightly odd features of the South African Truth Commission was that it had a somewhat religious feel to the process, in part because Archbishop Tutu was asked to be head and often began proceedings by engaging in prayer. And some people objected to the fact that the commission was starting off with prayer, and to which Archbishop Tutu replied, "The government knew who I was when they appointed me." And that was the end of the debate. But in the language of the Truth Commission, you will see that there's often references to truth, to forgiveness, to reconciliation, that all have this sort of religious dimension to it. I'm not entirely sure how I feel about that. I have great respect for Archbishop Tutu, and I think he made a huge contribution to the process. But I'm not sure I think that we all should embrace a sort of religiously framed Truth Commission process. The other processes, including in places like Chile, were not framed that way. But that's a separate, longer debate. So I mentioned that there was this one part that was focused on investigating the truth. There was another part that was devoted to the amnesty applications and adjudicating the amnesty applications. And then there was a third part that was meant to look at claims for compensation and to make recommendations for reparations. And I think actually the process more or less can be, in my opinion, viewed as the truth and investigation part having been the best, the amnesty part sort of middle and somewhat mediocre, and the reparations part quite pathetic. But most of my comments today will be about the amnesty part of the Truth Commission. And it's the part that I have the most issue with. So the amnesty provision was not automatic. There were criteria, and people had to make applications. And the criteria are somewhat reminiscent of just war theory or humanitarian law. I'll come back to that in a moment. The decision in this case, in the Azabu case, was rendered by a judge called Ismail Muhammad. And I think he has passed away subsequently. So again, forgive me for my criticism, but I'm not a fan of the decision itself. Judge Muhammad found, for a unanimous court, found that the TRC Act was constitutional and referred to the post-amble to the Constitution and its provision of amnesty. And as I said, I think it was probably a foregone conclusion that this was the case. And if the decision had simply done that, I would have had less of an issue with the decision. But the decision did not just do that. And it commented in ways that I think are unhelpful. So let me get into that. The first thing that Judge Muhammad did is he placed a lot of weight on the need for truth. And if you read the decision, it's almost this sociological comment on how the society was traumatized by the secrecy, by all of these hidden crimes that existed in South Africa. And when I read it, I sort of asked myself, was this really South Africa he was speaking about? Or was this more Chile and Argentina, where you had the disappearances, where you had this incredible secrecy? South Africa had certainly secrecy. We knew by then already about hit squad activities, secret police agencies that were engaged in acts of violence. But a lot of apartheid's terrible abuses were public. They were well known. They were widely condemned. What was really needed was some confrontation of the perpetrators and a judgment of their culpability. So Judge Muhammad put a lot of weight on this search for truth, and to the point that he suggested that the search for truth is more important than anything else. And I would compare that to a statement the Chileans made. The Chileans said when they struggled with the fact that Pinochet had relinquished power but still retained a great deal of power and limited the ability of the new civilian government to really go after Pinochet and his supporters. The slogan of the new civilian government post-Pinochet was the whole truth and as much justice as possible. Now you may think that sort of sets up a privileging of truth over everything else. But actually what it suggested was we cannot go forward without knowing the truth about it. We cannot live a lie. But justice is something that we struggle for, and what's possible is sort of an evolving idea. And over the next 20, 30 years, Chile has in fact achieved a greater and greater degree of justice with regard to its past than it was able to achieve in the immediate aftermath of the transition. Judge Mohammed referred to the experiences in Argentina, Chile, and El Salvador as support for the proposition that new regimes after transition sometimes give up accountability in exchange for truth, amnesty in exchange for truth. He was wrong about all three cases. In Argentina, there had been a transition where the military relinquished power because they had been humiliated in their conflict with the UK government over the Malvinas, or what the British called the Falkland Islands. And because of the humiliating defeat in Argentina, the military relinquished power and in a diminished position, and then a truth commission took place. And then prosecutions ensued. And at first, the prosecution started at the top ranks, and then it started moving down the ranks. And as it moved down the ranks, the rank and file started to protest. And that created political instability. Once it appeared that a lot of people were suddenly going to be tried and prosecuted. And it was because of the threat of a further coup that Argentina then adopted two laws, Punto Final and I forget the name of the other, but two laws that effectively amounted to an amnesty, or at least a cessation of prosecutions. So definitely not a case of truth being traded for amnesty. In Chile, Pinochet gave himself an amnesty before transferring power to the civilian government. And the civilian government decided it could only insist on truth at that point. But it turns out, so it wasn't that the civilian government gave amnesty. And years later, the civilian government and the civilian courts chipped away at that amnesty and declared it to be invalid. And in El Salvador, you had a truth commission that took place under the auspices of outsiders with UN backing that investigated the repression in El Salvador. And when the report was published, it named 200 people publicly. And because of the naming of people, there was suddenly a political crisis because people had been publicly singled out and named as perpetrators in the report, that the government hastily then retreated and said, wait, we'll give amnesty, because that had created a fear of a backlash. So I have doubts about this idea of privileging truth over accountability in the way that Mohammed suggested. Judge Mohammed put a lot of weight then on the fact that the amnesty was not automatic, that it was conditioned on criteria. So let me then look at that. There is no international set of criteria for the granting of amnesty. And hopefully there won't actually ever be a set of criteria. Why? Because you don't want to essentially legislate impunity. You don't want to create a license for perpetrators to then say, well, if I commit these crimes, here are the conditions I can rely on in order to seek amnesty after the fact. So South Africa had to look someplace to find amnesty criteria, and the place it looked was to the political offense exception to extradition. The practice of states, when one state asks another state to send a political prisoner back, or a political refugee back to that state, has often involved states making a decision whether or not to return somebody who had fled. Think of the IRA and supporters of the IRA fleeing to the US, and then the US being asked to send somebody back. The US courts then had to decide, should you send somebody back or should you not send somebody back? And this practice of creating a political offense exception to extradition developed. Those exceptions often look at what it is that the person is being accused of and whether they're being accused of a politically motivated offense. And if they're accused of a politically motivated offense, then typically they have not been sent back, except, of course, in some cases where those offenses were so atrocious that the government felt, well, these people deserve to be sent back to be held accountable. So South Africa looked to that as the basis for coming up with its criteria. So Judge Mohammed placed a lot of weight on these criteria, and here briefly are the criteria. The applicant had to confess to a crime. The act had to be associated with a political offense, associated with a political objective, and must have been committed during the struggle against apartheid. And the act had to be proximate to the crime, and it had to be proportional to the political objective. So the criteria required that the act could not have been an ordinary criminal offense. There was a flood of applicants to the Truth Commission, many of whom were ordinary criminals who just saw this as potentially a get-out-of-jail-free card, and they had no connection with any political. Those amnesty applications were denied. The more problematic cases are the cases that did, in fact, involve a politically motivated crime, and there, the key question was this proportionality question. Sorry, let me. So the proportionality criteria was tied to the political objective. For those of you who've studied humanitarian law or just war theory, this may sound familiar, but in humanitarian law, proportionality is to the military objective being pursued. And think for a moment about that, and I'll come back to that distinction. So, while these amnesty criteria sound quite reasonable, the process actually was deeply flawed. First, the process applied the amnesty criteria to everyone who came forward, whether or not they were opponents of the apartheid regime or supporters of the apartheid regime. Everyone came before the same process and the same amnesty criteria. Think about it. You had a liberation struggle fighting against a repressive regime. You had people like Nelson Mandela who took up arms and offered a justification for their use of violence against the state. And then you had thuggish repression that was condemned by the international community as part of something the world had called a crime against humanity. And both sides were said they should come before the Amnesty Committee and apply before the criteria. It has this appearance of even-handedness, but it also potentially has creates the appearance that in fact this is a sort of civil war between two sides who were being treated equally. In fact, that sort of equivalence tainted the entire process, so much so that by the end, even the ANC was reluctant to embrace the report of the Truth Commission because it felt that it had not done justice to the ANC's struggle. The second problem with the amnesty criteria is that it applied to people who had been convicted and to people who had not yet been convicted. thereby collapsing pardons and amnesties into one. And I think it's a very different matter when you consider somebody who's already been convicted, tried and convicted, and whether to release that person from a case where somebody had not yet been tried and convicted. But perhaps the most disturbing part of the criteria is that it perversely tied this concept of proportionality to political objective. Because, in fact, that encourages extremism. It said that your act was proportional to your political objective, and so the more extreme your political objective, the more likely you could meet the proportionality requirement. And there were, in fact, decisions by the Amnesty Committee that bore that out, that plaintiffs would fail, applicants would fail to get amnesty because their political objective was not as extreme as their acts themselves. But perhaps the most disturbing part of the decision was that Judge Mohammed considered the fact that the amnesty had been agreed upon in the context of a negotiated transition. That in fact the amnesty was sort of the price that South Africa paid for peace. And this has been an issue that has confronted many countries before. And while the de facto reality of not having the power to hold perpetrators accountable has been accepted, it's another idea to then legitimize your inability to hold perpetrators accountable and say, we will grant an amnesty because we don't have the power. So societies have been blackmailed in the past, and they've had to sometimes accept that blackmail. But they haven't gone so far as to try to legitimize the blackmail. And this decision suggests that, in fact, it is fair to give an amnesty in exchange for a transition. Sean, are we supposed to wrap up at 12?
At 12, so we're getting close.
Okay, we're very close. Okay. So then, let me try to close by saying what should one make of the decision in this case. I think, as I said at the beginning, that if the decision had simply been that the Constitution had provided for amnesty, the decision was probably the correct decision. It would have been very hard for a constitutional court to have said, no, you can't have an amnesty. And in fact, the amnesty was more limited than a blanket amnesty would have been. And in practice, because it had required that people come and confess, it did not grant widespread immunity, because many perpetrators did not even bother coming to confess. And they didn't bother to confess because the threat of prosecution was not a credible threat. And to this day, it's still not been a terribly credible threat. So on the good side, the process didn't result in a blanket amnesty. But on the bad side, I think the process has suggested to the world that there is a sort of truth and reconciliation approach, a restorative justice approach that might be an option for other societies going through transition. And I'm not sure that it is as meritorious as this decision or the process would suggest. So maybe I should stop there. I would love to tell you a personal story, but we might have to find another opportunity to talk about that, because there's a story about a Notre Dame graduate who appeared before the Truth Commission seeking, that's I'm going to leave the story hanging unless you ask me.
Well, thank you.
All right.
Garth, that was really...